Welcome back to another episode of Grizzly True Crime. My name is Gisela K, and today we're going to look at the clapback of the plaintiff's response to the defendant's motion to dismiss the complaint. In other words, we're going to look at the Petito's response to the Laundrie's trying to dismiss the complaint, the lawsuit they initially filed. Let's get started. Welcome back. If you missed the last episode that I did on this case, I actually read through the entire 20-page document of the Laundrie's filing for the dismissal of the lawsuit. So now this will be a response from the Petitos to that one. So if you missed that, I will link that below for you so you can check it out as well. It's not too long. I tried to keep this as short and entertaining as possible, even though it is kind of, legal documents, which some people are like, oh my word, yawn. However, it's important that we see what on earth goes on in this case, because at the end of the day, what we really want is justice for Gabby Petito. Of course, with Brian Laundrie taking his own life, there's only so much justice one can have. However, with how the Laundries treated the Petitos, I think that watching how this unfolds is quite interesting. So let's get started. This one is 14 pages long. Thank you so much to a Grizzly called Cheryl for sending me these updates. I get them immediately. So thank you so much. You guys know that I'm here in the Netherlands, so I need to put my VPN on to be able to see stuff like this. So I really appreciate it when you guys send me documents. You know I love documents, and if you just send me the documents in PDF format, friggin' love it, and I will read it to you. So let's get started here, let's go to the top, hold on. Okay, there we go. So filing number 147416356E filed on 04/11/2022 at 10:47 a.m. in the Circuit Court of the 12th Judicial Circuit in and for Sarasota County, Florida. Joseph Petito and Nicole Schmidt, the plaintiffs, versus Christopher Laundrie and Roberta Laundrie, the defendants. Case number is 2022CA001128SC. Plaintiff's response to defendant's motion to dismiss the complaint. Come now, plaintiffs Joseph Petito and Nicole Schmidt, by and through their undersigned counsel and response to the defendant's motion to dismiss the complaint, DIN 17, as follows. 1. Plaintiffs instituted the within action by filing a complaint on March 10th, 2022. 2. The complaint stated a claim based on intentional infliction of emotional distress. The plaintiffs are the parents of Gabrielle Petito, deceased. Gabrielle Petito was brutally murdered by the defendant's son, Brian Laundrie, also deceased, by a parent unaliving oneself. Plaintiff's complaint alleges that the defendants were aware that Gabrielle Petito was deceased and were aware of the location of her lifeless body, and despite pleas from the plaintiffs, the defendants refused to provide any information to the plaintiffs regarding whether or not Gabrielle Petito was still alive, and if she was not, where her body was located. Filed 04/11/2022 at 12:01 p.m., Karen E. Rushing, Clerk of the Circuit Court, Sarasota County, Florida. 4. Defendants filed a motion to dismiss the complaint on March 30th, 2022. The within response addresses the issues raised by the defendant's motion. 1. Motion to dismiss standard. And then they say number 5 here, a motion to dismiss is designed to test the legal sufficiency of the complaint. See the Florida Bar versus Green 926 SO 2D 1195 FLA 2006. In determining the merits of a motion to dismiss, the trial court must limit itself to the 4 corners of the complaint. Okay. A complaint should not be dismissed for failure to state a cause of action unless it appears beyond doubt that the plaintiff would prove no set of facts that would entitle him to relief. 6. The function of a motion to dismiss a complaint is to raise as a question of law the sufficiency of the facts alleged to state a cause of action. For the purpose of passing upon a motion to dismiss, the court must assume all facts alleged in the complaint to be true. Consequently, a motion to dismiss a complaint must be decided on questions of law and questions of law only. Consideration of potential affirmative defenses or speculation about the sufficiency of evidence which the plaintiff will likely produce on the merits, is wholly irrelevant and immaterial to deciding such a motion. 2. Alleged pleading deficiencies. 7. Defendants suggest in their motion that they assume the cause of action is one for intentional infliction of emotional distress, although the phrase intentional infliction emotional distress does not appear in the complaint, and also suggest that it is possible the plaintiffs might be trying to allege a cause of action for tortious interference with a dead body. 8. Nowhere in the complaint is there any suggestion that the claim is based upon tortious interference with a dead body. There are no factual allegations regarding interference with a dead body, nor is there any claim for the same. Simply because the words intentional infliction of emotional distress does not appear within the body of the complaint does not make the complaint defective. The elements of the claim are stated in the complaint. Let me know in the comments below if you think that this is a good and valid clapback to the Laundrie's motion to dismiss this lawsuit, and where you think this case will go next. I believe there's a court date set for, I think it is May 9th, if I'm not mistaken. So we'll keep an eye on it. I mean, I'm assuming that the Laundrie's lawyers will now also have a response to this, so we shall see. 9. Defendants also suggest the complaint is deficient because individual claims are not made on behalf of the plaintiffs against the defendants. The plaintiffs agree that the complaint should be amended to state such separate claims. 3. Alleged failure to meet factual pleading requirements. 10. In Metropolitan Life Insurance Company versus McCarson, the Supreme Court held that Florida recognizes the tort of intentional infliction of emotional distress as defined in, and then they quote this whole restatement second of torts 1965. So to all of you who commented, tort is so outdated. Pretty much, 1965. To state a cause of action for intentional infliction of emotional distress, a complaint must allege 4 elements. 1. Deliberate or reckless infliction of mental suffering. 2. Outrageous conduct. 3. The conduct caused the severe emotional distress. And 4. The distress was severe. Dependable Life Insurance Co. versus Harris, they give this example. 11. To satisfy the first requirement of deliberate or reckless infliction of mental suffering, plaintiffs direct the court to the following paragraphs of the complaint. 14. It is believed that on August 27, 2021, Brian Laundrie murdered Gabby Petito. It's still hard to read. The cause of her death was blunt force injuries to the head and neck with manual strangulation. 18. It is believed and therefore averred that on or about August 28, 2021, Brian Laundrie advised his parents, Christopher Laundrie and Roberta Laundrie, that he had murdered Gabby Petito. On that same date, Christopher Laundrie and Roberta Laundrie spoke with attorney Steve Bertolino and sent him a retainer on September 2nd, 2021. 21. After this point in time, there was no contact between Joseph Petito and Nicole Schmidt on the one hand and Christopher Laundrie and Roberta on the other. 22. From August 27, 2021 until September 19, 2021, when Gabby Petito's remains were found at the Spread Creek dispersed camping area in Wyoming, plaintiffs were extremely distraught and were attempting to locate Gabby Petito. 23. While Gabby Petito's family was suffering, the Laundrie family went on vacation to Fort DeSoto Park on September 6 to 7, 2021. 24. In an effort to avoid any contact with Nicole Schmidt, on or about September 10, 2021, Roberta Laundrie blocked Nicole Schmidt on her cellular phone, such that neither phone calls nor texts could be delivered, and she blocked her on Facebook. This is kind of like they're just repeating what they said initially. So let's continue to read through this and see if they expand on what they're re-saying here. 25. On September 14, 2021, with full knowledge that Gabby Petito had been murdered by their son, Christopher Laundrie, and Roberta Laundrie, through their lawyer, issued the following statement. It is our understanding that a search has been organized for Ms. Petito in or near Grand Teton National Park in Wyoming. On behalf of the Laundrie family, it is our hope that the search for Ms. Petito is successful and that Ms. Petito is reunited with her family. 26. On September 16, 2021, attorney Richard Stafford, on behalf of Gabby Petito's family, issued a letter to Christopher Laundrie and Roberta Laundrie as follows. We are writing this letter to ask you to help find our beautiful daughter. We understand you are going through a difficult time and your instinct to protect your son is strong. We ask you to put yourselves in our shoes. We haven't been able to sleep or eat and our lives are falling apart. We believe you know the location of where Brian left Gabby. We beg you to tell us. As a parent, how could you let us go through this pain and not help us? As a parent, how can you put Gabby's younger brothers and sisters through this? Gabby lived with you for over a year. She was going to be your daughter-in-law. How can you keep your location hidden? Her location hidden. You were both at Jim and Nicole's house. You were both so happy that Brian and Gabby got engaged and were planning to spend their lives together. Please, if you or your family have any decency left, they didn't, please tell us where Gabby is located. Tell us if we are even looking in the right place. All we want is Gabby to come home. Please help us make that happen. 27. Despite the fact that Joseph Petito and Nicole Schmidt implored Christopher Laundrie and Roberta Laundrie to tell them if their daughter was alive and if she was not, where her remains were located, Christopher Laundrie and Roberta Laundrie refused to respond to either Joseph Petito and Nicole Schmidt or law enforcement. Deliberate or reckless infliction of mental suffering on the part of defendants involves their conduct in refusing to speak to the plaintiffs when they knew full well that Gabby Petito had been murdered by their son and that they knew where the body was, that they deliberately took efforts to block the ability of the plaintiffs to contact them, that they went on vacation with their son who had murdered the plaintiff's daughter, while the plaintiffs were desperately seeking any information they could find concerning the well-being and whereabouts of their daughter, and that they issued a statement through their lawyer that they hoped the search for Miss Petito was successful and she was reunited with her family, all the time knowing that their son had murdered Gabrielle Petito and had hidden the body. I wonder how the Petitos know that they knew. I know that you guys are also asking that in the comments. I have the same questions, of course. Like, how do they know that they knew? I'm assuming based on them getting a lawyer on the same day, but it's going to be hard to legally prove unless they actually have like phone evidence, like the actual evidence from the FBI that shows that they knew. Number 13, the reference paragraphs of plaintiff's complaints sufficiently allege deliberate or reckless infliction of emotional distress. 14, to satisfy the requirement the conduct was outrageous, it must be so outrageous in character and so extreme in degree as to go beyond all possible bounds of decency. In applying that standard, it is manifest that the subjective response of the person who is the target of the actor's conduct is not to control the question of whether the tort occurred. Rather, an evaluation of the claimed misconduct must be taken to determine, as objectively as is possible, whether it is atrocious and utterly intolerable in a civilized community. That burden falls to the judiciary. It is a matter of law, not a question of fact. 15. At this stage of the proceedings, it is not the burden of the plaintiffs to prove the outrageousness of the conduct. Rather, the question is whether there are sufficient facts pled, and the allegations must be accepted as true. Connolly Supra. Based upon the paragraphs referenced in paragraph 11 above, plaintiffs submit that they have alleged conduct which is extreme and outrageous and goes beyond all possible bounds of decency. Can anyone truly suggest that it is not atrocious and utterly intolerable in a civilized community to refuse to tell grieving parents where their child's remains are located? 16. Further in support of the outrageousness requirement, unequal position of the parties in a relationship, where one asserts and has the power to affect the interest of the other, may also supply the heightened degree of outrageousness required for a claim of intentional infliction of emotional distress. In this instance, defendants clearly had the power to affect the interest of plaintiffs in that they knew the plaintiffs were desperately searching for their daughter. Defendants knew where she was and refused to provide the information. 17. In support of the third element of intentional infliction of emotional distress, requiring that the conduct cause the emotional distress, paragraph 30 of the plaintiff's complaint reads as follows. 30. Christopher Laundrie and Roberta Laundrie knew of the mental suffering and anguish of Joseph Petito and Nicole Schmidt, and knew that they could alleviate, at least in part, such mental suffering and anguish by disclosing what they knew about the well-being and the location of the remains of Gabrielle Petito, yet they repeatedly refused to do so. In doing so, Christopher Laundrie and Roberta Laundrie acted with malice or great indifference to the rights of Joseph Petito and Nicole Schmidt. This paragraph clearly states that the conduct of the defendants in not providing the requested information to the plaintiffs caused continuation of their distress, and likely increased it. The defendant's suggestion that the conduct of the Laundries had to be the sole and proximate cause is without merit, and defendants cite this honorable court to no authority for such proposition. 18. Defendants incredulously suggest the plaintiff's complaint does not allege, let alone factually support, that the emotional distress was severe. This is an ironic suggestion given that the defendants themselves experienced the same emotional distress when their son was missing. You know, I'm feeling like the Laundries don't have the same capacity to empathize with others, and they did not appear to be in the same amount of distress, but that's just my commentary for now. 19. Significant feelings of fright, shame, worry, and humiliation and others besides, occasioned by the acts of others are, even if regrettable, an unavoidable part of living in society. They are experienced by all of us. Complete emotional tranquility is seldom attainable in this world, and some degree of transient and trivial emotional distress is part of the price of living among people. Well, that explains why I don't want to live among many people. Okay, no, but they have a valid point. 20. Paragraph 26 of plaintiff's complaint quotes a letter issued to the defendants in which the plaintiffs state, "We ask you to put yourselves in our shoes. We haven't been able to sleep or eat, and our lives are falling apart. As a parent, how can you let us go through this pain and not help us?" 21. Paragraph 32 of the complaint states as follows. 32. As a direct and proximate result of the willfulness and maliciousness of Christopher Laundrie and Roberta Laundrie, Joseph Petito and Nicole Schmidt had been caused to suffer pain and suffering, mental anguish, inconvenience, loss of capacity for enjoyment of life experienced in the past and to be experienced in the future. 22. For the defendants to suggest that the plaintiff's grief and mental suffering was not severe is disingenuous and frankly disgusting. This case is not about fright, shame, worry, or humiliation, or transient or trivial emotional distress. Is there any greater horror for a parent than to lose contact with a child with whom they had daily contact, while the other party with whom their child had been traveling returned home safe, and that child and his family refused to provide any information regarding the plaintiff's missing child? 23. The allegations of the complaint plainly and clearly describe severe distress experienced by the plaintiffs. What are you guys thinking? Let me know in the comments below. I'm still hoping that this case will go ahead, but I'm fearing that by law, the Laundries are going to get away with this. As uncomfortable and ugly as that might be, you know. Anyway, okay. No, 4. Defendants' exercise of their legal rights. 24. Defendants correctly state that conduct which would otherwise be extreme and outrageous may at times be privileged under the circumstances. Metropolitan Life Insurance Co. Supra, however, the defendant's suggestion that they were entitled to such a privilege is wrong. 25. Defendants wrongly suggest that in this instance the First Amendment guarantees them the right to speak freely and the right to refrain from speaking at all. This is going to be an interesting clapback. Defendants cite to Woolley v. Maynard, which states, "We begin with the proposition that the right of freedom of thought protected by the First Amendment against state action includes both the right to speak freely and the right to refrain from speaking at all. A system which secures the right to proselytize religious, political, and ideological causes must also guarantee the concomitant right to decline to foster such concepts. The right to speak and the right to refrain from speaking are complementary components of the broader concept of individual freedom of mind." Okay. And they say the court reviewed, in Woolley Supra, the court reviewed a New Hampshire statute that required non-commercial motor vehicles to bear license plates embossed with the state motto, "Live free or die," and made it a misdemeanor to obscure the motto. The court noted that it was faced with a state measure which forces an individual as part of his daily life, indeed constantly while his automobile is in public view, to be an instrument for fostering public adherence to an ideological point of view he finds unacceptable. In doing so, the state invades the sphere of intellect and spirit, which is the purpose of the First Amendment to our Constitution to reserve from all official control. Defendants also cite to Miami Herald Pub Co. versus Tornillo in support of their position. However, as in Woolley, that case involves a statute, the Florida Right of Replay statute, that granted a political candidate a right to equal space to answer criticism and attacks on his record by newspaper, which also made it a misdemeanor for a newspaper to fail to comply. Therein, the court found that compelling editors or publishers to publish that which reason tells them should not be published violates the First Amendment guarantee of a free press. 27. A review of some of the cases subsequent to Woolley shows that the defendants' reliance upon a First Amendment argument that they had no obligation to disclose whether Gabrielle Petito was alive or where the location of her body was is misplaced. In Janus versus AFSCME, Council 31, the court ruled that the provisions of the Illinois Public Labor Relations Act, which forced public employees to subsidize a union, even if they chose not to join, and strongly objected to the positions the union took in collectively bargaining and related activities, violated the free speech rights of non-members by compelling them to subsidize private speech on matters of substantial public concern. In another case, the North Carolina Charitable Solicitations Act prohibited professional fundraisers from retaining an unreasonable and excessive fee. The charities contended that the act infringed upon the freedom of speech. The state argued that the act regulated only commercial speech because it related only to the professional fundraiser's profit from the solicited contribution. The Supreme Court affirmed the judgment of the Court of Appeals, holding that the act was unconstitutional and infringed upon freedom of speech. So here they're giving a lot of examples. They're going to give another one now. I feel like they're really trying to prove that point, right? The lawyers are like, really, no, we have a case here. So it will be interesting to see if this goes ahead or not. In Pacific and Gas, Electric Co. versus Public Utilities Com. 106 SCT 903, 1986, the California Public Utilities Commission required a gas and electric utility to apportion space in its billing envelopes 4 times a year for inserts of an opposing public consumer group. The Supreme Court found that this infringed on the appellant's freedom of speech by compelling the company to provide a forum for views other than its own. See also Bongo Prods LLC versus Lawrence, Tennessee Code, which required a sign with specific language regarding use of restrooms by either biological sex, regardless of the designation of the restroom, was particularly repugnant to the First Amendment, where the government was forcing a private party to voice the government's compelled message. McClelland versus Long, placement of signs by the county sheriff's office in front yards of residences of registered sex offenders within the county stating that there was no trick-or-treating at those residences, violated First Amendment rights because the signs were compelled government speech. Whoa, okay. I never really thought about that. Where I'm from, we don't do Halloween. I know everyone in America is going to be like, what? We don't do it in South Africa, and they don't really do it in the Netherlands either. But, damn, imagine trick-or-treating at a sex offender's house. No. Oh no, please do always accompany your children. 29. In this matter, there is no state action at issue, and the defendant's First Amendment rights are not implicated. While they may have chosen to say nothing, they have no constitutional right under the circumstances herein to remain silent. 30. Defendants also seem to suggest that they had a Fifth Amendment constitutional right not to speak in the face of a criminal investigation. Defendants then go on to state that there was unquestionably a law enforcement investigation of the Laundries regarding the disappearance of Miss Petito. Defendants' arguments are premised on alleged facts which are not within the four corners of the complaint and therefore should be ignored. Likewise, defendants' argument regarding the right to speak to an attorney has no relevance in this matter. 5. The plaintiffs must be present. 31. Defendants argue incorrectly that for the conduct to be actionable as an intentional infliction of emotional distress, the conduct must be directed at that plaintiff and in his or her presence. The restatement, second of torts, which was adopted by the Florida Supreme Court in Metropolitan Life Insurance Code, superstates as follows. Oh boy. Let's see. 1. One who, by extreme and outrageous conduct, intentionally or recklessly causes severe emotional distress to another, is subject to liability for such emotional distress, and, if bodily harm to the other results from it, for such bodily harm. 2. Where such conduct is directed at a third person, the actor is subject to liability if he intentionally or recklessly causes severe emotional distress. A. To a member of such person's immediate family who was present at the time, whether or not such distress results in bodily harm, or B. To any other person who was present at the time, if such distress results in bodily harm, underlining provided. See also Hablo versus Travelers Insurance Co. In all cases we have found in Florida, recognizing the tort of intentional infliction of emotional distress, the plaintiff was the recipient of the insult or abuse, or the message was clearly directed at the plaintiff through a third person. 32. In the within matter, plaintiffs have alleged that the conduct of the defendants was directed at them specifically, and they are not suggesting it was directed at a third person. Wherefore, for all reasons cited above, plaintiffs respectfully request this honorable court enter an order as follows. 1. Granting in part the defendant's motion to dismiss based on the plaintiff's failure to assert separate claims on behalf of each plaintiff against each defendant, and giving the plaintiffs 20 days to file an amended complaint to address such deficiency. Okay. Bring it. And 2. Denying the remainder of the defendant's motion to dismiss. This is from Patrick J. Riley, Esquire, Florida Bar number 0125109. I hereby certify that a true copy of the foregoing has been electronically filed on the 11th day of April 2022 with the clerk of court via the e-filing portal system, which will simultaneously email the same to P. Matthew Luca. That was the Laundrie's attorney now. All right. Whoa, so that's that. So now if they say this was filed on the 11th of April and they want 20 days to file an amended complaint to address any deficiencies in the initial lawsuit, we could expect, yes, by the end of April then to have an amended lawsuit from the Petitos, which will also be interesting to see. If you like me reading documents to you guys, I quite like reading documents to you guys. Please give this video a thumbs up. Leave your DNA on the thumbs up, I should say. Leave your comments below. I'd love to hear your thoughts about what we read here. At the moment, to me, it felt a little bit kind of patched together, like with all these examples and things. It doesn't feel very clear and direct. However, I'm assuming that whatever's going to be presented 20 days from the 11th of April, 2022, might be more direct, blunt, corrected, and all that kind of stuff to really clap back. But I suppose this was a legal procedure to, when they filed a motion to dismiss the complaint, this is now just to be like, whoa, 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 whoa. Before you dismiss that, to kind of appeal to the judge and say, no, we're not going to dismiss that. Just give us 20 days. We will make sure we fix what needs to be fixed and say what needs to be said. So it seems like it's still going to go ahead. And I think the court date, as I say, was set for like tentatively now 9th of May. All this back and forth might actually delay it a little bit, but let's see. Let us see what happens. So if you want me to read more as they come out, let me know below. I always look forward to it with you. Thank you so much again to Cheryl for sending me this. It's so nice to receive stuff like kind of hot off the press, fresh documents. I really, really appreciate it. I will see you in the next one. Thank you so much. If you're brand new here, remember to subscribe. I also believe that only, I think, 23% of Grizzlies have the little bell clicked. Make sure you click the bell and click all. That's not for me, actually. I can't even say it's just for me. It's not even for me. It's for you, so that you know when I'm next live streaming, uploading, or whatever I'm doing on this channel, so that you will be notified. Otherwise, you might miss it. And some people get upset with that. They comment like, oh man, how did I miss this? Why did I miss this? Also be sure to check that you are subscribed, because sometimes it just happens by default that people are like unsubscribed by, I don't know, some kind of YouTube update or something that happens. I'm not too sure, but just check that you are subscribed, that the bell is clicked, and I will see you in the next one. Thank you so much for watching.